Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome. Love to see that there's a bunch of y'all here. Shout out to James for being like number one. Like I said, I think it'll be a fun tradition to kind of do like Lawyer Lee does and say shout out to the first five. So shout out to James, who I think still does not have a custom command. Let us know if you want one, James. Shout out to Meg P. Shout out to Twiz. That's 3. Shout out to Iowa. And so far we got 4. So who wants to be lucky number 5? James also sent a super sticker. Thank you for that, James. Again, totally would love to have a custom command for you if you want one, since I know especially you were having fun with those last night. And I said shout out to Iowa again also. Welcome, everybody. So in case anyone's like, wait, what? Idaho on the screen? Yes. So it wasn't enough to warrant an entire live stream, but we do have something. We have a little updates here quickly. Yeah, you don't have to be green to have one. Anybody can have one. It's whatever you want. So the command would look like this, and then the response would be whatever you want it to say. So so just let me know, and then I'll pass it along to Nightbot. So still looking for whoever wants to be lucky number 5 in the chat. Okay, so here's what we're looking at. So we do have a new order, okay? But I just wanted to show you guys. So here's what we have. This is the new thing. But having said that, exciting news here. On the case summary, we finally have some new things that should be posting soon. So just let's take a quick look, see here. So look at this. So it's listed here on the 17th, right? So we could expect to see these tomorrow, or yeah, like tomorrow or the next day maybe. So so we have this objection to the defendant's objection. We have got a reply, we've got a response, another objection, look at this. Lots of filings. Oh, and then motion to redact or seal. Oh, fuck. Well, that's motion to file defense exhibits. Oh, okay. So the exhibits. So in other words, the pleadings should still be fine without the exhibits. And that's if the judge grants that, right? Because he's been more picky about that, which is a good thing. So it looks like we should still be seeing some documents for sure here. You know, one thing I will note is the subpoenas that have been issued we've still not seen those. But yeah, so we should be seeing some new filings. Other than that, we don't really have okay, no, we do have, so the exhibits we do have here. So the exhibits are under seal, which again is fine, but the motions we should still get, I would say. And then we have another motion to file defendant's objections. Okay, that's about the 911 call. Oh, crap. So hold on. 911 call. Okay, so then that got granted also. And now we've got some more responses, though. Look at this about the death penalty. Interesting. Look, tons of documents, guys. Holy shit. Tons of documents. Okay, so this will be Jesus Christ. Okay, tons of documents. Okay, so hopefully we will see those tomorrow or maybe the next day. Shout out to Fender. Fender's number 5. Shout out to Fender. So, you know, the thing is like these were all, looks like submitted on the 17th. So over the weekend, probably. So, well, I guess it would have been Monday, but yeah, usually it takes a couple days. So that doesn't surprise me. So I would expect to see these soon. Yeah, number 5. So I was saying I'm going to do like Lawyer Lee does. She does like shout out to the first 5 in the chat. And so we had the first 4 in the chat, and I said I was waiting for number 5. So top 5 babe, right, baby? Awesome. Look at how cute Batcat is. I love Batcat. And Heather, I don't think is here yet. Oh no, Heather's here. Heather's here also. Okay. No, we are doing the hearing. We are doing the hearing. I'm just showing you guys, this is just real quick because there was just a couple of new things that are going to be coming up in Idaho. And it didn't warrant a whole live stream. So we are doing the hearing. I was just starting with this. And then, so Fender was still number 5. Heather's number 6. We'll say shout out to Heather also. So we are doing it. We are doing it. So, okay. So, but I just wanted to take a look. This is the one new document that we can see. It's not long. Hoss long, not long. Okay. So order denying witness testimony at the April 9th hearing. So yeah, self-explanatory, but here's the part that is interesting. So it is hereby ordered that the defendant's witnesses, Cy Ray and David Howell, shall not be allowed to testify at the hearings April 9th and 10th. There you go. That's the newest document that we can actually see. So that's it. So that's it for Idaho. So there you go. So now we are going to go over to Karen Reed. Now here's what I want to do first. So I talked about this last night, about how I thought it would be interesting just to watch a little snippet of the first time we saw Brennan so we can compare it to now, because I think it's really crazy. So we're just going to watch a little bit of this, and then we're going to go over to the hearing from today. So, because there's a huge change. So let's here
is from Verizon, but I do have
to where we
motion for relief from the order to impound sidebar conferences.
To the court.
I'm just going to where
It's just for counsel.
here he is.
Before the SJC,
Yeah.
based on the request of the defense, if they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point.
I'm going to go ahead a little bit. I want to get to the part where he starts talking about his view on discovery and and it all seems like it's going to go so well.
We want to make sure I err on the side of caution and
Here we
they get
go.
every statement they're entitled to. So we're in the process.
All right, let me back that up.
The court prefers me to.
No, I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. So we're in the process of accumulating all potential statements of witnesses, which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14
Lolly sitting there being a potato.
parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together to adequately review it and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you, so we'll give you until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
As a matter of background, as the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were 2 different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics.
So what I'm going to do, I'm going to skip ahead a little bit. So remember, this is just to recap what we're listening to right now is we're just hearing a snippet from this is Brennan's first appearance in court. This is from November 11th of 2024. But we're going to hear him talk about his philosophy on discovery. We're going to hear him talk about also how he's going to winnow down the witness list and all this and that. And it's very interesting to put it into perspective as to how much things have changed in a short period of time.
He realized is that the information taken from the informatics manual and the information taken from the telestream manual had some regularities. What he realized is that all of that
Although
data.
I don't know how you did the star symbol. How did you do the star symbol? Because I don't think that's an emoji.
Because there was very obvious information missing from that procedure.
Yeah, again, they're talking about the telestream. I'm going to go ahead a little bit.
Infotainment system, there were actually
Infotainment.
it was to notice them. This is what we were going to do. You can see from my motion, I asked to do it within 14 days, having recently arrived. to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are two boards. One, the defense in their motion asks to have their expert be able to, but it was the defense expert that overlooked the proper
I
read of
don't even remember what ended up happening with this, with the telestream in the car. I can't even fucking remember. I feel like that just kind of never got brought back up again, because then all the shit went down with the Lolliport video.
going to do this. I know experts differ. They're not frick-a-frack. They
For January 27th. Sounds like you have.
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert.
Okay.
And that accident reconstruction expert will necessarily rely upon the
So now we know that's Judson Welcher, although he does hint at Kenny Kinsey at some point. But now we know it's confirmed, basically, now that we have the witnesses. I didn't even think to follow back up on this, that, when he mentions Kenny Kinsey, we talked about this and how maybe he was just maybe he asked for Kenny Kinsey to take a look, and Kenny Kinsey could not offer them an opinion that fit their theory of the case. So he references the name Kenny Kinsey, but they're not using him. And that's clear now.
information that is gleaned from this testing.
How long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And
So
the
I
sooner we
guess
have it, the sooner
maybe
we can
this
have it.
Judson Welcher dude is the dude who went and looked at the text stream. Although again, that in the motion that we just looked at yesterday, that wasn't even brought up. Let me see if James clarifies the stars here. Did you clarify about the stars? Let's see here. Yeah, it is trippy. The time zone thing is trippy. Of course, we have unconditional love for all of the squirrels. And including Fender. We love everybody, but Fender is the shit, as I said. Iowa will be listening. Love it. Yeah, let me know, James, about those stars, man. Too fast. I'm glad you're here. And I'm going to answer your question from last night because I think you fell asleep or you weren't here when I had an opportunity. Don't worry, I did not forget.
Our reconstruction expert engage in any type of task that we want them to, but they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay.
Okay, we'll go ahead.
Extremely
Again,
facile.
we're listening to the Brennan moments from his first appearance because it's crazy the difference. So I'm just skipping ahead to where we get to some more Brennan. Honestly, his tone is completely different, right? And he even speaks much slower. Crazy.
The expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is
And then back to the Mr. Burgess. Wait, maybe it's not Judson Welcher? I don't know. Mr. Burgess. Did we see a motion in limine about him? I'm just so confused because again, I feel like this shit with the text stream never came back up.
defense. They'll get an exact copy. The idea of checksum, there's no mystery to these. They confirm that nothing has been moved or destroyed. Defense.
All right. So if I act on this motion quickly, because there is.
Yes, this is Brennan's first appearance from November 11th, 2024. We're just watching little snippets because of the change that has taken place, the transformation, really, as it were. But we're just listening to the couple snippets here of him.
Isn't a basic objection to it being retested. When can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning. My expert encouraged him and insisted.
And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time,
Okay, here we go.
and I am newer to the case. I'm not looking for a personal accommodation. I
Okay,
think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as
Okay.
quickly as possible.
okay.
The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to
Here we go. Here we go.
January 27th, and I still am.
This is the part I was especially interested in.
If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable, began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get to a position where we're turning over expert testimony. They're retaining experts to counter that testimony and then to reciprocate discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to
For
defense
sure.
at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery.
For banks
And
are
certainly,
annoying.
the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbered, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution, so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of
What do you think?
inadvertent late disclosure or any concern or confusion about documents that have
You guys hearing this? This will prevent any concerns of inadvertent late disclosure. It's like all of this was imaginary, really.
been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on
It was also
investigating and
promising.
looking into the expert.
When it was also promising, guys.
So nothing is held back when I receive it. If I receive any information
Remember this day?
that is
Remember these?
discoverable or frankly not discoverable, I provide it to them.
Remember the boat times? Like old Greg. I mean, remember, like, listen to this nonsense.
If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices, when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it. I give it to the defense.
What about Lolliport videos?
And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of
That's key, I think.
reducing the witness list substantially.
Here,
And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial. And I think it will
reducing the witness list substantially. He added more witnesses than he removed, from what I could see. I mean,
be, importantly, more fair to the parties involved. And that's why I ask you to consider
like in other words, the net difference is more witnesses, I believe.
that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time
Under
with an expert of my
tax.
choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to your honor. Thank you.
All right. Who's going to argue this for the?
Okay. And so that's a good bit. Now, the other thing I will note is that in this hearing, and I think the next hearing, another thing that Brennan did was whenever he was referring to the Commonwealth, he would accidentally call it the defense. Because at this point in time, he still was like a defense attorney, right? You can hear it. Listen to how reasonable he seems. Listen to how fair. Listen to just, there's no ad hominem attacks. There's no exaggerating. Well, in hindsight, it seems like it's exaggerating, but I think he meant it at the time. I think he meant what he said at the time. And that's why I pointed it out. And I think it's important when he says, I'm just now getting into the discovery. He says again later, something like, I'm just getting introduced to this case. I don't know everything yet. And I think what happened is as time progressed and he got into the case, and then I think also something just with him being now part of it. Now he is, like I said last night, I think he is the Commonwealth. Like he is, I don't think he'll be able to go back. I mean, it is crazy. It's just crazy. So, okay, so we have James's new command. So now we're going to go to today's hearing. But what I want to do before I forget, and well, too fast, I think you're still here, right? Too fast. Make yourself known if you're still here, because I want to answer your question from last night, but I'm going to do it when I make sure that you're here. Because again, last night, I think you were gone when I was going to answer it. And I was like, that's why I didn't answer it, because I wanted to make sure you were here for me to answer it. So I'm just getting this pulled up. For today's hearing. Okay. What's 7 seconds? Shout out to Need Some Z's. He sounds like a politician, and politicians are generally dishonest. Also, the Commonwealth wasn't going to get someone who was interested in the truth. They want a conviction. Yeah, I mean, it's a good point. It's a good point. I mean, and we were giving him the benefit of the doubt. Super Planner Girl's here. Welcome. Happy to see you. In case you haven't seen it, we have memberships now for anyone who hasn't been here in a hot minute. I don't have mods. It's just me and Nightbot, you guys. Y'all know. It's like the opposite of your channel, King. So I don't think Too Fast is either here or is able to type right now. So we'll table Too Fast's question until Too Fast is here. So yeah, you just noticed the green names. Yup. Isn't it fun? Isn't it fun? So we will table that question until he is back. Okay. So now we will get into today's hearing. Let's do it.
Yay. All persons having any business before the Honorable Brennan Hanley, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. I'll take the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117 Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Morning, Your Honor. Adam Malika,
Good
Commonwealth.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor.
Brennan.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Mr.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr.
You just said Alessi, right?
Lassie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is
Okay, Too Fast is here. I'm going to answer Too Fast question from last night. Okay. So Too Fast was asking me last night, like how I got into, I guess the question was like true crime, but I think I don't know, like if it was just in general or specifically covering, but I'll just briefly, real quick. So I was raised watching Alfred Hitchcock movies. So anyone that knows Alfred Hitchcock movies probably sees exactly why that is significant, right? Because mystery, suspense, not necessarily crime per se, but more like the what's the word I'm looking for? The intellectual, or like, you know, the brain aspect of like trying to figure something out, right? What is the word I'm looking for? It's like a synonym for intellectual. Oh my God, what is the word I'm looking for? Anyway, that aspect, like the mental puzzle, if you will. Because with Alfred Hitchcock movies, there's never anything graphic or whatever. It's really just like oh my God, what is the word I'm looking for? Someone will put it in the chat, I'm sure. Yeah, so not savant, you know, like the mental, figuring it out in your head. Anyway, genius. Good words, but not the word I'm looking for. And thanks, Too Fast is repeating the question. Yeah. So I was raised on that, where it's like trying to solve the mystery, right? On an intellectual level, not like necessarily like seeing, again, there's no graphic imagery or whatever. Yeah, the mental challenge, right? For sure. There's another word I'm looking for. I'm sure it'll come to me when I'm not trying to think of it. The more abstract, I'm getting there. The more abstract solving of a mystery, if you will, or a puzzle, versus looking at things and solving it, if that makes sense. So, I guess that's kind of the word I'm thinking about. But anyway, so I was raised watching those movies, and my brother and I loved it, and you know, other things like that, or you know, movies, but there's also like the series, like the TV show. This is all old school, right? But like this is what we watched, and you know, we also watched things like all the type of crime stuff, and this is when we were kids, right? That was on that again. I wouldn't say it was necessarily graphic, but stuff like, you know, Unsolved Mysteries and Most Wanted and whatever stuff like that, right? But anyway, but I think Alfred Hitchcock had the biggest influence on me really wanting to try to solve that type, you know, solving the crime, solving the mystery, you know, like on an intellectual level. And then like, other than that, like, you know, I have always, I guess the thing that I found is that by being interested in that type of thing, where there's like, you know, I guess the quote unquote true crime, the true crime of it all is the law, right? It's the trial. And that's really what it is, right? Because I know true crime has kind of become like a genre. And the thing about true crime as a genre, as it has developed, in my opinion, is it's gone less from the true part of it, right? It's like the true part of it is the trial, it's the court documents. right? But the true crime genre has become more, there's a narrative and it's less true. And like, you're not getting the full story, right? I think you guys know what I mean. If you want me to elaborate, I can, but I think you guys know what I mean. And there's a budget and like da-da-da and the music and all of that is meant to, again, put a certain narrative forth to the viewer. And it's never the full story. And it's never completely unbiased, or subjective. It's not objective or unbiased. It is instead, it's more subjective. And it's sensationalized. And that's the other thing. Candace. Thank you. It's sensationalized. Yeah. Murder, She Wrote, and the other thing. Yeah. So then the other movies too, along those lines that we watched a lot as kids were like, Sorry, Wrong Number. Great movie. Dial M for Murder, that type of stuff. Great. Those are the classics. Right. And, yes, the enigmatic, right, for sure. Super Planner Girl. Yes. So yes. And again, the old school stuff is completely different than what we're talking about now. Right. And so for me, it's like I remember, for example, watching the, Making a Murderer on Netflix, right? That was from, I don't remember what year that was, but that was before I personally had discovered that you could even watch trials on YouTube. I didn't know it was a thing, right? As some of you guys have heard, I did not know that that was even a thing one could do until 2020. And so I saw the Making a Murderer and like, I thought it was really interesting, but I kind of even then got the vibe that it probably wasn't the full picture. And I would say that even since then, the true crime quote unquote genre has gone even further into different directions in terms of wanting to put something like it's really kind of exploded. And I think that was one of the first things that started it. Maybe. What do you guys think? I feel like that was one of the first things that really took off that I can think of, like as far as a Netflix documentary that got people interested in the quote unquote true crime genre. So anyway, but I watched that and that's about where it starts and ends for me as far as the Netflix true crime quote unquote documentary things, because again, in 2020, I started watching trials. And then I learned that you could find court and that's really just, then that's it. That's all I've been doing since. Right. And the more you want to know the truth of the truth in a crime or not crime, right? Where do you go for that? You go to the court documents, you go to the trial. And so again, the other factor here too, is like, I've been really interested in law for a really long time. And ever since I even finished my master's degree, I've toyed with the idea of going to law school. Still not ruling that out. And I have obtained a paralegal certificate and everything, mostly just because I'm doing this stuff anyway, but I wanted to be able to keep my options open in case, like, I don't know. I just don't know what, well, I like before I did that, like I already was studying this stuff anyway, right? For fun. And then I was studying it even more so when I started covering cases. And I've got, as you guys have heard, a whole stack of textbooks here. I've got the Federal Rules of Evidence, multiple different editions. I've got the Federal Rules of Criminal Procedure, multiple different editions from different years. And I've got I've got a lot of stuff to study the law. And so I got this paralegal certificate as well. And that was awesome because I got to actually draft pleadings. Our biggest last assignment was we actually had to write an appellate brief, which is a huge deal. And I had to write it using actual North Carolina case law. And that was one of the best and funnest things I've done. I freaking loved it. And so, and there's other things that we had to learn how to do that don't really come up as much when you're covering cases or covering trials. For example, how to write, citations properly and things of that nature. But anyway, so yeah, so I've done all that. And like, again, still not ruling out going to law school. And, I've learned a lot as well from the other law tubers, right? Like, but the way that I started covering cases, just again, really quickly in summary fashion, started with EDB and Debt v. Heard because, the sidebars came out and some person, who was in the chat or whatever had put up a super chat or something like that. And like said to EDB, like something like, and actually the exact question is in the intros to those videos. It's on the screen. So I don't remember it, but you can see it there. But it's something along the lines of what, like if somebody could take all of the EDB coverage of covering the trial and like splice it and set it up with the sidebars so that when it gets to a sidebar in trial, it then cuts to EDB reading the sidebars, you know, that would be the greatest thing of all time. And it would be like a law nerd hero or whatever it was. Right. And EDB responded and was like, that would be like a dissertation project. That'd be impossible or something like that. And I heard that. And in my brain, I was like, don't do it. Don't do it. Don't do it. Because once I heard that, the thought that that would be like the biggest enormous challenge for somebody to do, then it's like, well, now I have to do it, right? Because it's like an insane challenge that EDB herself said it would be like a dissertation project. She wasn't kidding. It's like a huge deal. And EDB didn't read all the sidebars. She read some of them. So me having no experience doing anything with editing videos or whatever, of course, I took it upon myself. And so I did that. So the first set was like the trial footage with her reading the sidebars. But again, it wasn't all of the sidebars. So when that was done, everybody was like, well, wait a second. What about the rest of the sidebars? Can you do the entire trial? Can you do the entire trial and read all of the sidebars yourself, the entire trial? And I said, okay. So we did that. We did that. I read all of the sidebars in context for the trial. And then everybody was like, well, what's next? And I was like, I thought I was just doing this one thing, but everybody wanted me to do something. And so that's where I was like, well, I know Murdoch inside and out. Let's do Murdoch. And it all took off from there, as you guys have seen. So that's the story. Hopefully that answers the question there. So now I'll take a look at the chat, see what you guys are saying. St. Patty's Day was yesterday, Kane. Oh, that's interesting. So Josh Ritter, and I haven't gotten a chance to watch that yet. I've been meaning to watch that on replay because I love Josh Ritter. He said he's a 58-year-old third-year law student. Okay, that's cool. And so some of you guys may not know, my dad, who passed away in 2014, he had a PhD in music. He was a super well-known jazz musician and professor. And he actually went to law school in his 40s. It's just funny. I think there's a huge overlap between law and music and the way the brain works. Twist said BRB. He might be back by now. I'm just catching up. Oh, so you still need some Z. So you started watching during the Deaf Heard stuff. That's awesome. I don't know if you were in the chat, but I'll tell you what was really funny is we used to have, there would be a lot of people in the chat. I remember during the Deaf Heard, I was usually doing the videos as live premieres, and then I tried doing a live stream. I had no idea how it worked. It was an absolute disaster, but I remember like there were like a lot of people in the chat, and I didn't even have any reference for it. It was like hundreds of people. And it was like, and literally the live streams were like, I probably deleted most of them, were like me, like, I can't figure out how to get this to work. And it was like, everybody was still there, even though there was like nothing on the screen. It was really fucking funny. You're very welcome, Too Fast. And I can elaborate too, but that's pretty much the long and short of it. Fender says she needs to log off. Okay, maybe you'll be able to come back again. That would be awesome. Sorry to hear that. What are you sorry to hear, James? Oh, about my dad. I bet is what it was. I bet that's what it was. Okay, yeah, thank you. Yeah, he was incredible, and he battled cancer for 15 years and fought cancer, as everybody says. Yeah, so yeah, I don't need a mod. Yeah, thank you, Tonka. Do I think Karen hit him? No, and I'll tell you what, like, what I thought until the ARCA dudes, again, I came into this case completely cold the first trial, right? I stayed away from it because of the toxicity. I had literally no thoughts. I knew nothing about it until opening statements. And that's what convinced me, because United's opening statements is when I was like, I'm going to cover this. I had no opinion. My opinion initially was, what the fuck is going on with the Commonwealth, right? Like, essentially, my opinion initially was, obviously, this is an easy not guilty because the case is fucked. Solo cups, leaf blower, stop and shop, the rest of it, right? But again, not guilty is different than like factually innocent, right? So I was like, obviously this is stupid. Why did they even bring this case, right? I was like, this is ridiculous. But in terms of whether or not Karen actually hit him, the ARCA dudes, he wasn't hit by a car. Therefore, Karen nor anyone else hit him with a car. So it's easy. It's easy. that, and I know I'm not alone in that, right? Like those ARCA dudes, those experts, it should remove the room for anyone to think anything differently, to be honest, right? And the only way I think that someone could maintain thinking that she hit him, or anyone else hit him for that matter, is the only way to do that is to do some mental gymnastics wherein you can try to discredit the ARCA dudes. For example, being like, well, we don't know, like what the jury said, right? Or some of the jury, we don't know who hired them. Was it Turtle Boy that hired them, or they're biased, or like finding some other way to discredit them would be the only way around it. Because if you listen to what they're saying and you actually pay attention and you're like, yep, I mean, it's clear. There's no way around it. So, so that's my thoughts, on that. Yeah. The ARCA dudes, I mean, again, even before the ARCA dudes, it didn't seem like he was hit by a car. Like, again, relying on common sense, looking at the injuries before the ARCA dudes, where I was at was obviously the case is messed up. They shouldn't have brought this case, right? They don't have evidence. What they have is shit, right? And it's just ridiculous, right? But also looking at what they had, which was shit, it's like looking at it, I think it was like, it doesn't look like he was hit by a car, using common sense, right? But again, I'm not going to rely on that yet to really, I didn't, right? I wasn't going to formulate an opinion for sure as to the, if he was hit by a car based on just my own, right? I was waiting for the, and then Trooper Paul came in, right? And it's just like, my God, right? I mean, honestly, Trooper Paul, if anything, made it seem less like she was hit by a car. But then you had the ARCA dudes, right? Or sorry, he was hit by a car. And then you had the ARCA dudes. And then it's a done deal for me. So, okay. So now we're going to jump into this hearing.
Was a decision on the Commonwealth's motion to exclude employees of ARCA.
Okay.
So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court.
Okay, so what's so funny is how many times did Hank Brennan say that they weren't trying to exclude ARCA, right? How many times did he say that? Like, and I'm going to pull something up real quick. But we know they don't want them to testify, but he kept saying that he kept saying, we are not trying to, exclude the employees of ARCA. And here's the thing that bothers me. So when they finally did move to exclude ARCA, right? I can't stand, dude. Okay. When they finally did move to exclude ARCA, it was because they said they weren't going to be able to get all the discovery because of the federal investigation details and the orders that prohibit the access to it. And that would be why. The issue of bias was a completely separate filing. Okay. And it seemed like there was not a motion for sanctions still on the table, right? Like this had been handled, I thought. So this is disgusting to me, and here's why. Because she's like saying, okay, I'm going to back it up. She's like, okay, we're going to address the Commonwealth's motion to exclude ARCA. And what does she do? What she's saying is not at all what is in the pleadings about that she's referencing. What she's talking about is really more akin to the motion for sanctions from weeks ago that I thought they sorted out when they dealt with the other, because remember, there was the sanctions that were on the table for the shit with the media. And it was like, don't do any more interviews or whatever. Okay.
So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
I just don't understand. Well, she's like making an argument that the Commonwealth didn't make in this pleading because they can't. It's unrelated. Like the candor to the court or whatever. That's just that is not. While she could, right? Okay. While she could exclude the ARCA witnesses due to the candor, this would have to be an action taken because there was a motion on the table asking for this due to the candor to the court issue. And that's not on the table. That is not what was in the pleading. And I am just blown away, actually. But I was going to answer this question here. So James is asking, does the Commonwealth get in trouble if it's a cover-up, fully knowing it? Should and will are different questions. Should they? Yes. Will they? Probably not. I mean, speaking of candor to the court, right? I mean, yeah, they should. And that's part of what, I'll be honest, part of what the defense has alleged in certain filings, especially as it pertains to like DA Morrissey. I mean, that's something that, again, I didn't follow this pre-trial, but now I know that pre-trial, this was a thing that was talked about a lot with DA Morrissey. And that's why they have him on the witness list and stuff. Like they are under the impression that DA Morrissey was complicit. And that, like, not just that it's a cover-up and knowing it and not doing anything, but really more like being part of the cover-up to begin with. So, but that's all just being shut down. So, yeah, I'm not. I admit, yeah, I'm not. I mean, it was a valid question. And I mean, I know, so I'm answering the question and, you know, one would hope that they would do better, but you know, what is the saying? Like, what is the saying about like the definition of insanity is doing the same thing and expecting different results? I guess kind of applicable here being that not doing the same, like we're seeing them do the same thing, right? And why would there be a different result, you know? So this is crazy.
I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar and open court.
Again, the closest thing that would come in terms of the pleadings, the thing that would come closest to what she's addressing would be the pleading about the bias. But that's a separate pleading, and that's not what the pleading she's talking about. And even still, in that pleading, they did not ask for sanctions.
Court and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case.
I mean, y'all, this was from the beginning of the month, March 5th and 6th, I believe it was. And, you know, one of the things I said at the time was like, it seemed like this was water under the bridge. And what I said was, she's not going to exclude the witnesses or remove the attorneys, right? Or even a attorney, because she would have to push back that trial date, right? And what have I been saying this whole time? She's April 1st or bust, right? So let's see what happens.
The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court.
It's crazy.
So
it's crazy.
I find
absolutely crazy. And it's honestly, it's also late, right? Why the fuck didn't she say this at the time when this was being addressed? This was not still on the table.
Or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So,
You know, I will be honest. I think that part of what this is, if not all of what this is because they basically solved the issue, right? The whole thing about the payment and everything, that was all clarified, right? And to the extent that there was a narrative, I don't even know if there was, but for some people who maybe were like, oh, now look at the defense, they're being shady, da, da, da. That seemed to be, if that existed, I would imagine that sort of went away, right? And that's no longer being something that is, you know, and now what's been happening? Well, we've got all these motions in limine. We're talking about the expert witnesses, you know, da, da, da. And now she's bringing it back to this. Like, honestly, it seems like just to rehash or retread old ground that's not relevant or related to anything, just to try to make it seem like the defense, just to try to make people think that defense was doing something wrong or something. You know what I mean? Policy. I agree, Candace.
all right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be.
So she's just basically invented another motion on the table that she's now going to rule on, apparently.
All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses.
What is the fucking point of all this? This is insane. This literally is just beyond. This is beyond.
Don't expect to have to address this again. Candor with the court is essential.
She's not removed. So she's not doing anything. Literally, all she's doing is giving them a warning and scolding them. You've got to be kidding me. All of that. Listen, guys, what she just said was, I can't trust the words that you say. It was a flagrant violation. I mean, if she believed what she said, she should have removed them, right? But instead, and whether her motivation is to try to put this back into is to try to get this, because now what's everybody going to be saying? Like, I'm sure in the media, I would imagine all the media is going to be talking about is the first part of what she said, right? I bet there's clips all over the place. Here's of her just of the initial part that she said, I mean, scolding them, but not the next part, right? Where she because they go to sidebar. And then I'm sure you think about most people's attention spans, right? She's like, this is a warning. You can still stay. This makes no sense. If she really believed it, she would remove them. So either this was her just saying that because she wants to put this media back in, or narrative back in the media, and or she believes it, but she's not going to do anything because April 1st or bust, right? And she knows if she does remove any of these attorneys, then there's going to be a problem. There's no way they're going to April 1st. So hold on. My external monitor just try turning it off and turning it back on. Hang on. Are we okay? Well, you guys are still here. I'm still here. I'm just trying to get my external monitor to work here. So yeah, so it's just interesting. That doesn't surprise me though. That's wild to me. And that's the thing, right? So she just gave, basically, for the people who really want to convict her or whatever, she just gave everybody fodder for that, right? She just gave everybody fodder. And, you know, again, I think part of it is because this matter seems to be settled, right? There was no, it wasn't as bad as she made it seem. Remember when she freaked out and she did all that? It's like, it wasn't that bad, right? And dude, it's just crazy to me. And the jury pool. Yep. So, I know. So this is, so nothing's happening. Like, you're just scolding them on camera in front of for literally no reason. You're like, this is a warning and that's it. Nothing's happening. Like, this is insane to me.
It's the bedrock obligation of all lawyers who appear in this court and all courts.
Right. And to the extent that anybody thought it was bad, I mean, the whole thing was just settled, right? So
in Massachusetts, a lawyer's only as
she's
good
she's trying to rewrite history and make it seem like it was bad, is basically what I think the long and short of it is.
as his or her word. And I need to be able to take counsel at their word. So,
and if
I'm
you
not
really
going to-
believe you can't do that, then you remove them and you continue the trial date. That's the thing.
tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the court.
What about Brennan? Oh,
And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the Aruba Witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery.
so literally, this is just despicable. I would have been, listen, as much as I would have said it was completely unfounded and whatever for her to either remove the attorneys or exclude ARCA, I would actually, it would have been less despicable if she actually did that. And here's why. Because then at least it's like you truly believe what you're saying, right? Even if I disagree and I think she's wrong, right? If she says everything she just said about the candor to the court and all those issues, but then she said, because of that, right, I'm going to remove Mr. Jackson or I'm going to exclude ARCA, then at least that is consistent, right? And it's not hypocritical. It's almost worse to me that she's not doing anything, because then it just makes this completely transparent as to why she's saying it at all for no purpose.
Discovery obligations.
I mean, for sure.
I will allow a full cross-examination, Mr. Brennan, and
What have you
I will
listened
review
to?
any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Leslie. You didn't have a chance last time on the motion to exclude.
That's incredible. Like, again, there was not a motion still on the table. And what has she found? Nothing changes anything. Attorneys are still there. She's not even giving them a fine that we know of, right? For sanctions, like a fine, you know, not even that. And ARCA is still testifying. Literally, oh, wow. She just wanted that to get back in the media. I mean, yeah.
Include the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
I need a 5-0 break. I need a 5-0 break. Because it's too much. 5-0 break. 5-0 break. Hold on. Let's do the things. Let's get rid of 5-0 real quick. We're going to do this the right way.
Yesterday, I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendy made another new friend. Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know? Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just come
I'm
up?
going. Sorry. Heather, Heather says, I met a new friend on a whole hawk. Bitch, how old are you?
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys. Andy's friend, the fucking mortician. What is happening?
I ate a lunch. Like, I had a whole delicious lunch.
And just for good measure, we're gonna do so whenever I talk about this theory that I'm like, I don't even know how to explain it because it makes no sense. We'll listen one more time, we'll put 2 more seed. This is it. This is the whole thing right here. This is it.
I'm trying to tell her that this is a big deal. Like if we go to the police on the second extortion, they're going to catch the second extortion, and when they catch them, they're going to turn, and the second extortion is going to turn in the first extortion. And then when you catch the first extortion, the police are going to come talk to us. And then when we tell them what happened, you're going to be in a lot of danger. There's no way I can talk to the police. So by catching the second, it's going to turn in the first. And that's exactly what I say in there.
So you know what's so funny is that for Frankie Figs, aka Franks, her command wasn't working the other day. This happens randomly, or maybe Nightbot is just being slow, but for whatever reason, that command is not coming up. I'm going to try it again. Nightbot. Oh my God, so good every time. Couldn't agree more. Also, Kane said you can call her Amanda. I just have to say, I have known Super Planner Girl for years, and I've met her in person, and I know her name is Amanda. I'm just that she added that recently, and I'm so used to not saying her name, like, because in other words, it was always hard because I know her name, and like I just had to get really used to the habit of not accidentally saying her name, and whether it's in a chat or on a live stream. Anyway, I'm just so used to calling her Super Planner Girl. She's still Super Planner Girl, even though, yeah. So, anyway, I don't know why that is not Nightbot. I mean, again, and this is where I'm like, well, wait, was it pieces plural? I think it's piece singular, but let's just increase because Nightbot's not doing the things. So there it is. It's pieces plural, I think. Okay, there it is. That's what I wanted to pull up for Charlie there, but Nightbot was late. So, okay. That was the 5-0 break, and now we're back. I think we're on to what motion? Let's see.
Of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Motion.
So we'll move on to Mr. Leslie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So
Okay.
I'll hear you on that.
Thank you, Your Honor.
So many Dr. Wolf, Doctors Wolf.
May it please the court. The
Hello,
proposed
hello.
testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong 1, and 2, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated.
I'm glad you enjoyed
In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. and specifically in his report, which is Exhibit A to our motion. The entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, one paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coup contra coup mechanism.
Huh?
Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does.
Interesting.
So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist.
I love how Court TV adds it. Robert Lusty, and then let me pull the banner down so you guys can see. This is really fucking funny. Robert Lusty, defense attorney. By the way, did I see a derp durable or am I crazy? Because derp durable, if I missed, or maybe I'm just remembering that from earlier. Derp, oh, he said gerbil cancer. I saw gerbil and I thought derp durable. Meg, if you're still listening, derp durable for life. He said incurable cancer.
Just and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scordi-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scordi-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a pedologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dahlberg-Lanigan factors.
I made a new command.
So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to—
Everyone's been trying to figure out how to make an emoji for derp durable. So the best I could think of was because there's no vacuum cleaner yet. I don't know why there's not a vacuum cleaner yet. I did a broom, and because it came from a dirt devil vacuum cleaner, so we have a broom and a devil. I mean, that was the best I could. I don't know why there's no vacuum yet. That would have solved it. But yes, that's where we got derp durable. There we go.
To also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury
What were
is. So
you
I'm even
saying
going to
about
assume for the
cleaning up
moment
the
the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury. And that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology. Number one, it doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy. And we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner. He's not a forensic pathologist. He has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article.
I find it interesting that they want a neurologist to be able to opine on the manner of death. It doesn't make any sense. That's not their... Like, in addition to Dr. Squirty, but like, it just doesn't, and I don't understand. Anyway.
And I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing, because we, and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts, where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the 2 prongs of the Dalbert inquiry?
That's awesome.
All right. Thank you.
Twiz, I wish you could. What were you talking about earlier with cleaning up the chat? I just don't know if you're talking about, I just didn't know if you're talking about this chat or if that was a joke about mods or whatever. Anyway. So, yep, Turtle Boy's in the court. Yep. So it's interesting. So you'll notice he didn't mention Dr. Crosby, and that's because she already ruled on that, right? But she has not ruled on the other witnesses who also did not offer any methodology and whatnot.
Mr. Brennan?
Oh, gotcha. Okay. That's funny. I can't see that on StreamYard. That's interesting. I guess on YouTube, you can see, I guess, when a comment is deleted or whatever, but you can't see that on StreamYard. So I had no idea. Okay. Thanks for letting me know. All right. It's Brennan's turn.
May I?
Please.
Attorney Leslie mistakenly
Oh, at least he got his name.
misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami.
So yeah, so we actually covered this at the beginning of the live stream, but basically the Judge Hippler denied the request to have him testify at the upcoming hearing, not at the trial, but at the upcoming hearing. And James has become a new member. Love it. Awesome, awesome, awesome. And yeah, for anyone who missed it too, it looks like there's a ton of documents that should be coming out here, hopefully tomorrow, but if not tomorrow, then maybe the next day. So.
Neuroscience Center for 17 years.
Thanks again for
1993, 2011.
Thank you.
The busiest.
James has been very, very generous, and I appreciate it. And we're glad you're a member now as well. So
Neuroscience Center in the country. He has treated
not
tens and
trial,
thousands of
just
patients
hearing.
with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research
Too long to list. You still can, dude.
Is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injury.
A slew of them.
Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16.
He's not addressing any of the argument that was just made by Mr. Lassie. This is just reading off of the CV.
In which is the
you're
document that I produced to
your
counsel last night, listed in his journal articles, number 16. Fractures of
just give
the
it a
clivus,
membership.
classifications and clinical
That's
features.
awesome. I love that so
His
much.
journal articles
We should
are
have a
numerous,
member.
too numerous to go through, but you can see that he is well published, over 70 articles, presentations specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries.
What do you mean, agency?
Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall
What the fuck?
backwards on the ground. It can't occur
Counter-coup.
from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the
Wow.
brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and
But
didn't
this sounds
diagnose.
like a rebuttal witness because, again, it sounds like it's just trying to disprove that he wasn't hit by something in the house, which we don't even know if they're going to try to say. This is all very silly. His voice causes death. I agree, Candace. James, thank you again for the another super sticker or another super chat, rather. I've been patiently waiting for caps. Yeah, so I'll read what Heather said as well. So Heather's basically saying here that what Cy has provided to the court will still be a part of the hearing. It's just that he personally isn't going to be testifying. So again, and that's in reference to the April 8th hearing, not trial. I mean, and a great question, right, Twiz? You can't do more damage with a bat than a fall. Yeah, I've stopped trying to pick apart what he says because it's just, you know, we wouldn't make it through 2 words at a time without stopping it. You know what I mean? But a great point that you're making as well. Oh, 9th. Okay, sorry. 9th, not 8th. Okay. Thank you. That's really funny, Heather said. Oh, said that phrase. Okay, contra coup. Yeah, I understand that, Kane. Yeah. It can be a little bit much to read sometimes, but yeah. Yeah, so Twiz is going to be making a D-spur and bringing it to the hearing when he goes. So D-spur is the same thing as a display.
Diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is
You haven't
that
seen anything
the
about
body
that,
was moved. There's
doctor.
no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord.
I mean, to the extent that this is accurate in terms of the brain, again, fire hydrant, anybody? Also, if I didn't mention it, this will also redirect you guys, fingers crossed, into the next stream, which is going to be the Lori Vallow hearing. So,
And so his opinion
double hearing day
is clearly supported by his extraordinary experience, his writings,
extraordinary.
his history.
Extraordinary.
It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth, but we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Ellis, anything final?
Yes, thank you, Your Honor. Thank you.
You guys, hold on. Hang on.
Your Honor, I'm going to note.
Y'all see his face when he went to get up and he said, "Thank you, Mr. Brennan." Hold on. That's funny. Hold on. Let me back it up. Back it up. Watch.
Anything final?
Yes, thank you, Your Honor.
All right, I just sped it up. I need to put it on normal speed so we can actually see this, what I'm talking about here. He made a funny face. And then he also says, "Thank you, Mr. Brennan." Should say Brennan.
Thank you. Mr. Ellis, anything final?
Yes, thank you, Your Honor. Mr. Brennan. Thank you.
He had like a smile there, Chelsea. Interesting.
Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Dalbert factors.
Oh,
And that
like
is-
literally what I was saying. He's not addressing at all any of the argument, right?
the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death. Because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025.
The reason why this matters, because manner of death, right? Of course, that's going to be homicide, right?
Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own.
It's just like we've seen this with other experts, right? Like he's really well qualified, but not at this thing, right? Like he's qualified to testify about the stuff that we heard about in his CV, right? And for example, like again, sounds like he's a cancer specialist, you know, but that's the problem, right? You have to be qualified at the thing that they're offering you for.
Words. He said cause of injury.
Great question.
And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand, many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may.
How
This
is
is
there an objection?
relatively straightforward and relatively short.
How is there an objection? This is their witness. Dude, I said this before when we covered the motion. I was like, doesn't make any sense that the Commonwealth would not want this, because shouldn't they want the jury to understand the evidence they're putting forth to try to prove that the shards of glass came from the I don't even know what it is they're trying to say, if it's from the cocktail glass or the taillight, but either way, whatever it is they're trying to prove, wouldn't they want this?
I have a question. Did you use this last time? It looks like
We attempted to use it. We had it last time. It was shown to the
Right,
witness.
I
It was
remember
not
that.
allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
did she adopt it? Was there okay?
She did indicate, and that's part of my argument, Your Honor, which is
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have. So you're just trying to use it as a chalk, not an exhibit.
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an
The
objection?
pieces of glass was useless. It needs an exhibit.
Be a partial objection to a chalk, some of the labeling.
When they
I
say
have
chalk, by the way, that just means exhibit.
less concern of a chalk as I do.
Good night, Candace.
And so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will
I mean,
recall
right?
this-
Yeah,
this
and it was really kind of a rhetorical question, neat some Z's, but yes, thank you. That's exactly why.
deals with glass.
Rhetorical question, because obviously that would be the only reason, but it's just pisses me off.
Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex. The court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very
That is
difficult.
what it sounded like, and it was just useless. When we talked about this last time, everybody that was here in the chat felt the same way I did, which is like we just kind of, it was just all a wash. We didn't know what the fuck she was talking about, so it just didn't affect one thing or another. It was just pointless, right? Which again, if you're the Commonwealth, obviously that seems like that's what they want. So
It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the date of her testimony?
Gosh.
Ms. Little?
okay, and it's funny because a lot of times when we hear the word demonstrative, usually they say demonstrative exhibit, which that's a good point. So there is a distinction, right, between things that can be just so I guess usually the way I hear it is usually demonstrative aid, right? So there's things that can just be a demonstrative or demonstrative aid. And then an exhibit does go back with the jury, and they're actually talking about that, right? He wants it to go back with the jury. And so I didn't know if there was a distinction in terms of which one a chalk always means, but that he did say that they want it to be used as a chalk and an exhibit. So I guess there is a distinction here for that. But sometimes you hear demonstrative exhibit. So I would imagine that would be a demonstrative aid and an exhibit that goes back for the jury.
Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her.
That's
on
hilarious
the-
because he literally said demonstrative aid. There you go.
on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now, I think waiting on Ms. Hanley's testimony would
A
be.
demonstrative aid and a chalk are the same thing. As in, not necessarily also an exhibit, meaning not necessarily also going back to the jury. So then if it's an exhibit or a demonstrative exhibit, I would imagine then it's implied that it's also going back with the jury.
Apropos, and then we'll ask for its submission at the right time.
No.
All right. What's the objection, Mr. Brennan?
Well, at least you're honest about it. See, that way, at least you just make sure if you're ever called for jury selection, make sure you say that when you get called in for voir dire.
This witness has a report, and the
here we
report is
go.
not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now that is...
Okay, so he's referencing the documentary. Guys, I heard a whiff about the documentary and ABC's, I think, just mentioned it. What documentary is it? I don't even know what it is, but he just referenced this. Let me back this up. Interesting. Okay, so ABC's is asking, why can't her report be evidence? So reports are technically hearsay. I don't think, I'm trying to think if there's been an exception ever where the report goes back with the jury. I don't think there is. You know, the expert witnesses write these reports so they can provide it to the other side, so they can be prepared at trial. And remember, the expert witnesses can't even refer to their own report unless they ask permission. May I refer to my report? Yes. Now, there was, I forget which trial. There's been a handful of trials where, again, this would be up to the specific judge or the court, where every expert witness just had their report and read from it and didn't have to ask. I'm trying to remember where that was. It might have been South Carolina. But anyway, that's not normal. Normally, you're not allowed to use your report unless you ask, and then you just have to look at it and put it back down, right? You're supposed to be testifying from your memory. So the report, you know, again, not even just going back with the jury, but in terms of like it's the point of the report, again, is to give the other side an idea of what the expert is going to be testifying to, and they can use it to refresh their own memory when they're testifying. So Need Some Z's says about the first trial. I'm not sure what you're referencing. Are you saying that's what the documentary was about? Oh, okay. It's on. Okay. Yeah. So I don't have any way to watch that then. Yeah, it is a shame they didn't allow Mark Betterow. That's a good point. Nothing is stopping him from making a demonstrative. Don't be jealous, Brennan. That's hilarious. Fender's back. Yay. That is so funny because I think you're already gone, but I was like, maybe you'll be able to come back. And here you are. Excellent. So right now, on the bottom of the screen, the ticker is saying what's happening. Right now, we are on the defendant's motion to include the glass. I put glass demonstrative because that's the easiest way to call it, right? It's what they're calling it, a chalk. So this is the one from Christina Hanley, with the shards of glass. And we are on the Commonwealth's argument right now. And what I just backed it up. You're a great place to come back. I just backed it up because he's referencing something from a documentary that just came out. So let's listen.
The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that.
Oh. again, this is referencing the documentary that just aired, and ABC's docket has watched it and said it's on Investigation Discovery and HBO. I don't have any way to watch it, but I'm backing this up again. This is interesting. I think Need Some Z said it was about the first trial, although I'm not entirely sure that's what she was referencing, but it seems like it maybe was. But this is on a documentary, and this just aired, and now he's referencing it.
That the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now that
You guys
is
want me to not use the ticker?
the first time we've had any statements from Ms. Reed suggesting that. And also there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night.
I only did
And
this
secondly,
for
I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it.
So I was just saying, and I'll back it up here. I was just saying, do you guys want me to not use the ticker? So the only reason the ticker is there is to help you guys. But if you guys either can't look at it or don't want to look at it or whatever, for any reason, then there's no point, right? Because, yeah, so if you guys don't want me to use it, I can take it down.
Statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important.
I'm
But
saying it's not about me. I don't have it there for me. I almost know what we're doing because I'm streaming it. I have it there for you guys.
looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this,
You need to consult with an
Oh
expert
my
as
God.
well.
Sorry.
Um,
Wow. That's the Lori Vallow hearing. Sorry. Oh my God. Hold on. I just was trying to pause it and oh my God. We are professionals, people. Hold on. What was I going to say? Dear Lord. What was I going to say? I was saying, I'm not proud of it. Y'all, it's not hard to make a ticker. Oh, I know what I was going to say. I was going to say that the reason I have it there, especially is for people who maybe are joining at some part during this stream, for example, like, or coming in and out like you, Fender, right? Literally, that was how this whole thing, so that people know where we're at. So, you know, what some people do is they will pin a comment in the chat, but you can't do that on StreamYard, I don't think. I'll double check, but I don't think you can. So that's why the ticker is what I had, but it's not for me, it's for you guys. Right, exactly. So the only thing that makes sense is because it doesn't help the Commonwealth because their evidence is shit, right? I think Need Some Z said it very astutely earlier because I was saying the same thing as in like a rhetorical question because we talked about this when we covered the court filings. And then, oh wait, not there, not that one. Hold on, different one. Right. Here it is. Because if the jury gets confused and can't take the evidence into deliberation, then it's better for the Commonwealth. So. Yeah, I can't pin comments. I just double checked and I can't pin comments. So that's why I have the ticker. You can't hear it? Are you guys not able to hear it? Is it just weird? That is very weird. I don't know why. I can hear it. That is odd. You know, I feel like this has happened to some other channels. Let me just try this again. Weird. I wonder if it's a StreamYard thing or a YouTube thing. Can you guys hear me? I swear to God. Let me try this again. James literally, as I'm like, this is not working. You guys can't hear it. Thank you, James. I appreciate that. Just the video all of a sudden. Okay, let's see if this is any better. Can you guys hear it now?
Your Honor, thank you.
All right. Who's going to argue this for the defendant?
Let me back it up a little bit further to where we were.
That's why I asked you to consider that continuance. I do not expect that we come before you and ask another
You want to
continuance.
hear
If
it?
something cannot get done in time with an expert of my choosing or that I would like, I appreciate I
Shut
won't be
up,
able to use an
Liz.
expert. And so I think the joint request.
I mean, I
is
didn't
something
turn the sound off. I mean, I've got the sound is on.
that is legitimate.
Can
I
y'all
think it's
hear
well
it?
thought, and I leave it to your honor. Thank you.
All right.
I
Who's
appreciate
going
you,
to argue this for the
James.
defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion,
I'll
I
just
agree with
it
the
down.
argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the timeframe, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts, depending on what the testing.
Have you been working on that, though, in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into.
Oh my God, this is the wrong thing. Is this the wrong thing? Oh my God. Oh my God. What is happening? What did YouTube do? Hold on. It's playing the hearing from November 11th. No wonder I was very confused. Oh my God. Hold on. Jesus Christ, what is happening with YouTube right now? Hold on. This was, guys. I will say this much. This just goes to show you how much we all have been tuning Brennan out that we did not notice. You guys, y'all. I was like, wait, why is it only 34 minutes long? Also, that's what she said. I'm dying. Hold on. Oh my God, you guys. Okay.
Open to discussing chalks with the defense.
Here we
and,
are. Now we're back.
Perhaps learning
Jesus
why
Christ.
they think this is helpful or important, but looking at this chalk does not look clear to me. And I
That's
do
the
think
point.
that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Yeah, you know what I think it did? I think it went back. I think what happened was somehow, I don't even know how. I tried to just click pause. It tried to press the video, it should pause it. And instead it played the previous hearing because we watched that first. So anyway.
All right, so Mr. Jackson, what I'm going to do is just hold off.
Yeah.
Hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence
I
again.
understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of
True.
seize the day. It's
Good
Ms.
point.
Hanley. So I do
Good
think
point.
if the court would keep an open mind,
Sure.
Ms. Hanley testifies, then that would be the appropriate.
Yes.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great. Thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion in limine to admit the victim's out-of-court statement relating to a state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses?
Oh my God.
I'm just wondering if they're
Aruba
hand in hand.
Sisters
So,
Sullivan.
The paper number on the Commonwealth is 585. It's got your 11 on it, though.
Great point. So some people have said BRB.
So the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with let's just say the Aruba
The sisters Sullivan.
witnesses.
Get it right, Bev.
Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the quals, bans the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We do
Okay.
not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Okay.
There we go. All right.
Good.
All right. So Mr. Brennan, you can have a seat again and we'll go through the defendant's one. That's very
Nice.
helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank you.
All right. All right, so that was 5:59. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for review, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I know.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
That is so interesting because I was wondering that last time because we wouldn't have known if she was there or not. And remember, I was like, that's interesting. If I were the defendant, I would not want to be there because the jurors are probably going to be judging you, right? But anyway, so that's interesting. So the difference here is that they want Miss Reed to be present.
Okay,
Yes, Your Honor.
so I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client
Yeah.
attending it.
Yes, Your Honor, there was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm. How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Are you
Okay, what are
joking?
you proposing for that?
You're
We
joking.
could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so
Oh
it
my
creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions,
Yeah.
timing conditions. And I think
Oh my God. Yeah, I agree. Do you think he needs to see this should, yeah, the frustrated needs to see because Brennan doesn't object. Yeah, he's done this before, right? He's done this before where he's like, Aruba Witnesses is great. I don't object. I don't object. I don't object. And then and I mean, I guess that's similar, but not exactly the same thing. But yes. But now he is objecting on this one particular element. Like he initially says he doesn't object. And then she asks about Karen Reed being there. Now he's like, oh, I don't want the car there at the same place. When, I mean, it was at the first trial, and this is absurd.
it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
Or so I need some proposal. So I need more information
She
from
would stay
both.
in the
So
car.
Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we do.
That's a great point. Yeah. So what I said about this too is I was like, if I was the defendant, I understand wanting to go, but I would want to stay in the car so that the jurors aren't just looking at me. You know how they do, right? They're going to watch and judge her no matter what she does or doesn't do. So it sounds like that's what they're wanting. But yeah, I agree. They should make them go at night.
Decide, we may have to do it all at once.
I do
So-
think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have.
I think Judge Bevel will let the car be there, especially because, if nothing else but for the saving time element, how she is. So
Have Ms. Reed be able to attend, so let's figure out some particulars. All right, so defendant's motion limited to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562, did I say 4? Sorry, 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure.
this is specifically about like the McAlberts being in the courtroom and intimidating the jurors, essentially.
Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. He or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we joined in that request.
Okay.
The only exception I would
I
note.
haven't seen Grandma's Boy either, but thank you, James, again. James is like a patron of the channel now. Speaking of which, people have asked if I have a Patreon. I've never even been to a Patreon. I don't even know what they do. Anyway, I will just say that James is like the patron of the channel at this juncture. So appreciate
Is
it.
that experts should be able to obviously watch other expert
sure.
testimony that deals with their.
All right, so obviously is not something that should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I don't want to speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
Oh, boy.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name
Wait.
Higgins,
Bashing?
Albert. They invoke those names. They characterize third-party culprit. And they suggest that some anonymous person was uncomfortable. It seems as though the presentation
Anonymous because they're
has a deliberate point.
Brennan.
Promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may, or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Making a record at the sidebar. Making a record at the sidebar.
One might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
Oh boy. All right, guys.
That's also on, Your Honor.
Okay.
Okay. So this is, guys, okay, since I took the ticker down, just in case it bothers anybody, we are now getting to the motion in limine regarding the funds paid to ARCA.
I believe the Commonwealth has indicated that they will agree to that.
Okay.
James, you don't have
All right,
to
so
pay
paper
$2 every time you
565,
please.
allowed by
I
agreement.
know you know that, but thank you.
So 566, defendant's motion for panel voir dire. Who's arguing that?
What did they end up saying about the ARCA? Hold on, let me back it up.
That's Your Honor. Thank you.
Okay,
Let me back it
so
up. What did they end up saying about this? Hold on.
okay. 5, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also on, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by
So it's a
agreement.
non-issue. It's a non-issue. Okay.
So 566, defendant's motion for panel voir dire. Who's arguing that?
That's Your Honor. Thank you.
Okay, so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to panel a fairer and more comprehensive jury.
Okay, what's the Commonwealth's position?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire. But I want you to agree to it. And if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that. And what Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. .570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? A low cost standard, right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There's no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where? When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't
They
think
did not
that we
open
had
the door.
opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed.
Yeah.
So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been
My
intimidated by anyone.
recollection of that whole thing when she blurted that out was it was really non-responsive to the question because she just was waiting for an opportunity to say that, right? And the question did not open that door. It doesn't surprise me that Judge Bev made that finding.
They have you. Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. in any event, I think the court understands what our concern is with regard to the subject matter. We don't want a free-for-all of people, one person after another, walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality.
Oh my God,
and
stop,
grossly
dude.
Misstates the history and facts of this case.
Exaggeration and the hyperbole. I'm just over it, man. Listen.
Important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed
again with this documentary
talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious.
I know ABC's has seen this documentary. Has anyone else seen it? But to anyone who's seen it, is that accurate? Let me back it up.
Appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years.
Absolutely.
In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note. Okay?
Of course.
All right, go ahead, Mr.
I
Jackson.
just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. So sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What's fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay, thank you. I'm gonna look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first. And we would respond, including with regard to the motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth versus Hanley, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right, now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy dixit and saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, Serum Plasma Conversion Report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in the serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors. And it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All
It
right.
should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever reference that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion in limine to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
So Fender, I didn't know you had bangs. Okay, let's go ahead. Okay. So,
All right, for the court, please.
You are muted.
oh wow. So yeah, so basically I will say, so they come back apparently. Yeah, this trial is different in so many ways. I don't even know how somebody would begin to explain. I think if that's what you guys are asking. James also said another super chat saying that Heather is unique. I would agree. She is definitely unique. Okay, so I guess they come back here or thereabouts. Cool.
So, Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st.
Oh, wow.
The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago.
Bye, Fender. Good luck with your client. We love you.
Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes, okay. Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached, and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be due 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right. Thank you very much. Does it make sense for me to hear from Mr. Spillinger directly, or do you want to handle this, Mr. Brennan? Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit.
Absolutely.
The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which aren't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss in a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So
I will
I'll hear
say,
you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
so real quick, so I actually just bumped up the time because we're almost done with this. And then it will redirect you guys into Lori Vallow. Speaking of Chad Daybell and Lori Vallow, so let me just go forward here. So it should be in just a couple of minutes, we'll be able to redirect there. Okay.
All right, tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
Hold on. That happened so fast. That's what she said. Let me hear that again.
All right, tomorrow, but Thursday morning at 9 o'clock. That'll
Okay.
give you time, Mr.
Okay.
Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay, so see you Thursday. All right, thank
Couple things. So ABC's docket is in Kansas. So they were supposed to be coming back tomorrow, and instead they're coming back on Thursday, right? That's what she said. Or that's not what she said, as in that way. But let me just we'll see you Thursday. She says, okay. So they're coming back on Thursday. So there you have it. So let me actually just update this stream. Give me just a second, and we'll portal right on over. Anyone who wants to take Chad and Lori's portal, feel free. If not, totally understandable. You can take your own. Looking at you, Twiz. And we will definitely have more Wendy clips. Don't worry. We'll actually do a couple right now before we shuttle on over to the next stream. So, okay.
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening?
I ate a lunch. Like I had a whole delicious lunch.
Okay, so we don't know yet if it's going to be continued. I just don't see her continuing it. But sounds like we should find out more on Thursday. And honestly, that kind of works out because I'm really hoping tomorrow we get a lot of those documents out of Idaho and that we can cover those. And yes, we have a lot of dog lovers here. For those of you guys who don't know, my dog is Frodo. Looks like a little red fox. He has great big ears. He's the love of my life. So, taking the mortician to the pool for the free. Yeah. Oh my God. So yeah, that's a part of why I was saying it's very apt that Heather is bringing up Chad Daybell because we're about to shuttle on over to Idaho. So we're taking a trip from Massachusetts, not Idaho. Oh my God, Arizona. Taking a trip from Massachusetts to Arizona. So with that, I'll go ahead and roll the outro. It should transfer you guys. If it doesn't, you guys can click on it, obviously, live stream. But I will see you guys here in just a second. Love y'all, and I will roll the outro.